The recent release of Netflix in Australia has reignited debate about the legality of using VPNs or virtual private networks to access streaming services located overseas. The problem arises where even though users may pay Netflix a subscription fee to use their service, Netflix does not have the right to grant Australians access. Simply put, VPNs allow users to access unlicensed content. The announcement of Netflix's availability in Australia and its similar pricing to the US does not automatically translate to an eradication of the VPN issue. Content availability on Australian Netflix is still significantly lower than its overseas counterparts. This drawback, coupled with the complication of switching services, means that many VPN users may continue to access the overseas services rather than sign up here in Australia.
Previously, Netflix was only available to a few countries outside of the US due to licensing complications, but was quite easily accessed by people outside of the US via use of a VPN. A virtual private network serves to mask a user's geolocation and allows them to use an overseas IP address to circumvent Netflix's block of users outside of the US. The illegality or legality of this practice is complicated by the fact that these users still pay Netflix for the service no differently from anyone living inside the US.
The issue of whether this practice is an illegal infringement of copyright is yet to be determined by an Australian court. However, there are several legal consequences which may arise for users accessing Netflix. The first is a breach of the Copyright Act 1968. Section 10 of this Act deems it illegal to access any content that has technological protection measures. There is a strong chance that the court may find that geo-blocked content falls under this definition. Alternatively, members of the legal community believe that geo-blocking does not satisfy a technological protection measure and therefore not covered by the Copyright Act. The second legal action which users may face is repercussions from content providers, internet service providers, and VPN providers. Under Australian law, it is unlikely that a copyright infringement would occur where users receive a communication from a content provider located overseas such as Netflix. However, if Netflix itself was sued by copyright owners for providing unlicensed content to overseas users, it could potentially choose to seek damages from users who they could prove signed up for the service fraudulently. A third consequence for users is potential criminal liability. Although a user does not need to provide an address for signing up to Netflix, using a VPN to access geo-blocked content may constitute unauthorized access to restricted data. All in all, there is yet to be an Australian case which deals with this issue, nor a High Court ruling which interprets whether geo-blocked content constitutes a technological protection measure under Section 10 of the Copyright Act. Due to the lack of relevant legislation, the fact that the service is paid for, and the inefficiency of prosecuting individual users, people in Australia who access Netflix via a virtual private network are highly unlikely to face any action for copyright infringement.